into the microphones or direct your voice and your mouth towards the microphones when it's being live streamed. If you're not looking at the microphone, if you turn to look at someone else, it doesn't pick up all the noise.
Where would Tyler be on a nice Monday night like this?
Yeah, I tried to do the
He's
live
not
stream.
here.
Could you watch them?
He's not here.
Yeah. And
I'll
instead of
enter my
watching,
inner
I was
Chad and
listening.
see if I can.
Oh, while it was happening?
Yeah.
Good.
No, not while it was
All those
After
times
the
I
fact,
saw
yeah.
you excel at it, right?
Yeah, because I didn't know it was going to be live streamed until later.
Do you have that little
That was
cheat?
the very last
Do you have that
thing.
cheat
I
sheet
don't know if
thing
it
for
was
me?
a link or something.
Do I?
Anyway.
Yeah.
I gave it to Tyler. This may be a field promotion.
I know. I mean, he didn't give it to me.
Oh, yeah.
I'm guessing he's not going to be here if he's not here yet.
I'm way down at the bottom.
Oh, I'm way at the bottom. There's nothing right on the agenda, is there? There's no, nothing here.
Yeah, because at the end she had other stuff, like just large chunks of these. And so what they'll see is just this.
Okay. Sweet. Are you going to come to my office tomorrow for
I can, yeah.
one with Trisha? Or do you want to just do it from your office?
It's up to you. What's more convenient?
Wow. Someone
Who's the
sent
guy?
an email supporting Win. You see that?
What do you want me to do?
I think that's the assistant.
So let me ask you this. If I had a motion to make, would it be here or after or here?
I would think it'd be
Two?
there.
He is here?
I don't even know.
Yeah, him sweating.
Proud of him. Probably just
6 and north.
Okay.
That's where, the south stuff.
Okay.
out by Autonomous.
We'll call the meeting to order for December 11th. And first up is roll call.
If you give Jolie a second, she's gonna start the recording.
Oh, okay.
I wanna make sure and point out before we do that, when you are, as I tell you myself, as you are speaking, make sure and try and identify into the microphone so that the sound gets picked up on our live stream and the recording for minutes purposes.
Okay. This meeting will be for today, December 11th, 2023. Welcome to the December 11th, 2023 Planning Commission meeting. Thank you for your attendance and participation. In order to ensure a fair and orderly meeting where everyone can participate, the commission requests that you act respectfully to everyone in attendance and follow the procedures. And now we'll do roll call.
Tyler Timbrink,
Here.
Jeanette Johnson,
Here.
Chad Depperschmidt,
Here.
Brian Aubert,
Here.
Ken Corbett,
Here.
David Linderman, Josh Greening.
Here.
With 6 members present, there is a quorum.
Okay. Communications from the public to staff.
If you notice that I did place a packet on each of your spots with emails that were received. Some of those were received right before and after last month's meeting, and then a couple that we received in between then and today. And we wanted to make sure that each of you had a copy of those, and so I printed those off and gave them to each of you.
Thank you. Any ex parte communications by members of the commission? None? Any conflicts of interest by members of the commission or staff? None. Okay. So we will hear the Assistant County Counselor on legal issues surrounding wind and solar farms.
How are you switching? That's fine. Oh, okay. Okay. Good evening. Yeah, my name, as Tyler mentioned, my name is Kyle Edelman. I'm an assistant county counselor with Shawnee County. I'll be honest, when Joni and former county counselor Jim Crowell approached me about doing this presentation, they at least implicitly led me to believe that this would be a simple task. It ended up being a little bit longer than I intended. So I guess what I'll do, and I kind of talked to Joni about this, I'll go for an hour, and if you want me to stop at that point and come back, let me know. It's just, it ended up being a lot of material to cover and try to synthesize, and some very large, broad legal topics to cover. I did want to start with a disclaimer. Essentially, this is a general overview of the legal landscape. Please don't take anything I represent to be specific legal advice that might apply to a specific proposal that the commission might consider in the future. This is simply to help you as you start considering proposals when you get to that point, to identify issues that you may confront or be thinking about as you're starting down that path. I also wanted to acknowledge Trish Voth with Fulston Siefken. She presented in 2022 and 2023 to the CCAK, and I borrowed from her presentation and her outline for portions of my presentation here tonight. So I did want to acknowledge her contribution. And with that, we'll just start with basic Kansas land use law. So county authority for land use regulation in Kansas generally comes from 2 sources. You have your Kansas enabling statutes and you have your home rule authority. The zoning enabling statutes in Kansas are found at KSA 12-741 through KSA 12-775 and KSA 192956, and that should say through KSA 192966. The latter two of those are for your urban counties, so that would apply to Shawnee County. Chapter 12 is going to apply to any county that's not designated an urban county and actually has zoning statutes. All counties have statutory home rule authority. This is particularly relevant if it's a county that doesn't have zoning statutes in place. But Shawnee County obviously uses home rule authority for various things to regulate property in the county. So your home rule authority statutes are found at KSA 19-101, 19-101A through 19-101F. I also listed KSA 19-212. That's the powers of the Board of County Commissioners. Those are explicitly laid out in statute. And then I sort of went through it, but what the last two bullet points there are hinting at, generally land use regulation, it's viewed as a use of traditional police power authority, and so as long as a county is exercising that power in pursuit of the traditional police power functions, so your health, safety, welfare of the public, courts are generally going to give the county deference as it regulates land within its county, or within its jurisdiction, excuse me. And then I did prepare a slide, just a refresher on Shawnee County's amendment, or adoption and amendment of zoning regulations. Specifically in this case, 19-2960 is the statute that we'd be looking at for adopting or amending zoning regulations. And that lays out the procedure that you would follow. I listed the actual steps and they continue on to the next slide. I did want to highlight, I know I watched the last meeting, the live stream from it. I did want to point out, I think under 19-2960, it's worded weird, but essentially the commission would be required to hold a public hearing once you had a proposal. So I'm not saying you would be prevented from having public hearings. There's nothing in law that would preclude you from doing that now, but you would have to have another public hearing once you had a specific proposal that you were looking to forward on to the Board of County Commissioners, if that makes sense. And then go to the next slide. Obviously, you guys are pretty much aware of these. I just wanted to refresh your recollection to the extent it's necessary. And I did want to, if you have questions throughout, I wanted it to be informal, so feel free to raise hands, yell at me, whatever you want. Next, we'll talk about, I wanted to talk about moratoria or moratorium. So this is essentially an interim development control device to preserve the status quo for a reasonable duration to conduct necessary research and make appropriate findings to reach a decision. It places restriction, I guess, in reading the cases, counties did it, or authorities did it differently depending on what they decided to do, but generally they place a restriction on the acceptance of applications and or the granting of special use permits or conditional use permits for a specified duration and time, but may not be extended. There are several cases in Kansas, one out of Saline County, or was it Salina, the city of Salina, that dealt with whether or not a moratorium was a taking under the Fifth Amendment's clause. We'll talk about the Fifth Amendment later on in the presentation. In that case, the Kansas court found there was no taking. In that case, similar to the Zimmerman case that we'll talk about later on, that was based on there wasn't any vested property interest at stake. So there was no property interest for the county to take when it enacted the moratorium. Other than that, so again, go ahead.
Can you speak up, or can we turn a little bit so the crowd
Yeah.
can hear better?
Sure. I think my cords will allow.
Oh, you can't read, oh.
That's okay. I've got them here.
Oh, you do, okay, thank you for that. And if anyone would like to come up to the front, there's 4 seats in the front, if they can hear.
And there's also seats outside in the entryway on video with the TV set up, so you can hear it out there as well.
No, you're fine. I'm gonna run out of the
If you would, sir, line up a few booths and might be closer to.
They're not amplified.
They're
It's just for
recording.
recording.
Yeah.
I'll try
Sorry
to speak.
about that.
No, no,
Thank
no,
you.
you're fine. So this is a lot of words to basically say the county's exercise of land use regulation must be both lawful and reasonable. When of course looking at whether or not it's lawful, it'll look at statute and whether or not proper procedure was followed, and whether or not the county exceeded the statutory grant of authority. If, assuming it was lawful, it'll move to a reasonable analysis. And that's the second half of that slide. So the second half is the test the court will apply when analyzing whether or not an action was reasonable. Really the only thing I wanted to point out is Kansas law is pretty explicit on it will evaluate whether or not the action is reasonable based on the facts that the county had before it enacted anything. So it's not going to be a we pass it and then defend it in court with facts that we figure out later type of situation. It has to be facts that you all considered, facts that the Board of County Commissioners considered before enacting anything. These are the golden factors. You all know them. You've dealt with them a lot. So I just listed them. I think where they fit in the scheme of things is it's essentially the Kansas Supreme Court saying, if you do these things, we're really likely to consider what you did reasonable, if that makes sense. So this is just, I kind of borrowed this from Trish and her presentation, but she just kind of generally what counties consider when they're passing wind and solar regulations. So aesthetics, impacts on property values, restrictions on property rights, use of roads, setbacks, and then consider, are we regulating utilities currently, and how do we do that? Consider, are we regulating power lines running under the ground currently, and how do we do that? Those sort of things. The Gump case out of Wichita, that's, aesthetics are not in the golden factors, as you know, and so that was kind of one of the first recent cases that identified, yes, they're not in the golden factors, but a county can consider them when passing. In that case, it was a conditional use permit, but obviously in this case, we're talking about countywide zoning regulations. And then I wanted to highlight, so KSA 68501, and that section deals with county's obligations and duties towards roads and township roads. And it specifically mandates that we hire a county engineer. Kurt Niehaus fulfills that role for us. I think he would be a good resource for you all as you're considering, okay, broadly speaking in the county, how's our infrastructure built to support moving these things in and out? Are there county roads that he's identified as concerns? Are there portions of the county that he's identified as concerns? That sort of thing, if that makes sense. So the other topics that I've identified through case law and that we'll kind of cover tonight, you're looking at Contracts Clause of the United States Constitution, the Takings Clause of the Fifth Amendment, and Article 12 of the Kansas Constitution, the Interstate Commerce Clause of the United States Constitution, and then state and federal preemption. I'll leave that. So really the two cases, well, the two opinions in Kansas that are most relevant for you all to consider are Zimmerman, what I've identified as Zimmerman 1 and Zimmerman 2. The first opinion, they're actually the same case, but they're two opinions by the Kansas Supreme Court. So the first one came out in 2009 and the second one in 2011. This is the case that followed Wabaunsee County's amendment of their, countywide amendment of their zoning regulations to prohibit commercial wind farms but allow small wind, I don't want to say wind farms, but small wind siting facilities. How do they? Small wind energy conversion systems. My bad. I'll get there.
I have a question on that.
Uh,
Yeah, yeah.
Was that just private level wind?
the way I interpret, at least the portion of the opinion that cited the regulations, the way I interpret small wind energy conversion systems as they defined it, yes, you're looking at a single turbine for personal use.
Gotcha.
And the single turbines were low, like 100 feet, I think, as opposed to 150. They had to be below 100 feet tall. And I meant to check, Jody brought it up. I think since then, Wabunsee County has been, I think Mr. Swati mentioned, brought into the prohibition against, so they no longer have to worry about it, but this was during that period of time before they were completely covered by that. So again, basic facts. So landowners and other interested parties brought suit against the county following a countywide amendment of the zoning regulations which prohibited commercial wind farms but allowed small wind systems. At that point, certain landowners had entered into written contracts for development of commercial wind farms on their properties prior to the adoption of the amendment of the zoning regulations. And I think the other owners of land and wind rights were presumably the companies themselves, sought to intervene in the case and were allowed to intervene. Sorry, my nose is running. I did want to note, they did institute a moratorium at some point, and the court, it'll apply later on, but the moratorium was passed prior to any of the contracts being entered into. So that was sort of, they did the moratorium, and then the contracts were entered into, but in any event. So just a broad overview of the pertinent holdings. The first one being that the court found that the countywide prohibition was reasonable land use regulation, and the county could rely on aesthetics and conformance with the comprehensive plan. There was also an argument regarding community views. The court reaffirmed, I think it's long-standing case law at this point, that it's unreasonable to solely consider the views of the community, but it's reasonable to consider the views of the community, but the views of the community alone would not be sufficient. The court also found that zoning regulation did not violate the Commerce Clause, and then it found it wasn't preempted by state and federal law. And that was sort of what Mr. Svati was talking about when he mentioned that essentially the court kicked it to the counties as far as citing wind and solar facilities. And I won't get in, preemption is a whole nother mess, so I'm not going to get into it. It's sufficient that you know at this point that we're not preempted from acting, but if the state or the federal government decide to act in the future, that would be a concern, and we might need to reevaluate our regulations. They obviously are the higher authority, so if either one of them decide to pass something regarding citing wind or solar in the future, we would have to reevaluate. So yeah, countywide the Kansas Supreme Court held that the countywide regulations were reasonable. The court did touch on lawfulness. Obviously, Wabunsee County was under Chapter 12, so I'm not including that analysis in our discussion. It just went through the procedure that they went through. There was an argument that they didn't follow proper procedure. I think if I recall, the Planning Commission rejected the idea, but the Board of County Commissioners ended up adopting it.
And didn't send it back.
And didn't send it back. So a majority of the Board of County Commissioners adopted it over the objection of the Planning Commission, and there was an argument about whether or not that was lawful. I think under Chapter 19, they have to send it back.
The way that the statute reads is that they're supposed to send it back to the Planning Commission with directions and instruction on what to reconsider at that Planning Commission meeting. It can be very specific, and it doesn't have to be another public hearing. It can just be a consideration without actual public hearing, but it would go back to the Planning Commission and then back to the Board of County Commissioners after that.
Yeah. Yeah, again, the court reiterated the scope of judicial review, and what I mean by that is essentially what the court's going to look at when analyzing reasonableness. It reiterated that there was a presumption the zoning authority acted reasonably, and the decision will be held unless it's arbitrary and completely misses the mark. Again, I wanted to highlight the only review facts that you guys had or the Board of County Commissioners had before when they passed this amendments.
I'm sorry,
The-
what was that last part?
The only consider the facts that you guys had before you or the Board of County Commissioners had before it, when it passed, if it ultimately passes an amended zoning regulations. Does that make sense? So like, at these hearings, you all are collecting evidence and facts. Presumably, the Board of County Commissioners will also conduct public hearings or bring in people to talk. And so what the county did was prepare transcripts of all those meetings. I think it was over 400 pages, close to 400 pages of transcripts. And they presented that to the court. They also prepared written findings that they had prepared. And we'll kind of cover some of those as I go through it. But
Okay.
yeah, it's...
So I'm going to interject just a second. He means the court, what the court would consider if they're reconsidering or hearing something if a lawsuit gets filed after the fact. They're not going to have a whole new hearing and be able to hear new facts. They only consider what was heard at the Planning Commission and at the Board of County Commissioners. So attorneys couldn't start bringing in a bunch of additional details that were not considered by the Planning Commission and the Board of County Commissioners when they made their decision.
Gotcha.
Yeah, we wouldn't, yeah. So we wouldn't get to district court and say, well, Judge, we want to bring in expert Y to talk about wind turbines and how they impact the environment. The court's going to say, well, what evidence did the Planning Commission or the Board of County Commissioners have regarding wind turbines and their effect on the environment when they made the decision? Does that make sense?
Sir, could you please speak up?
Yeah, I'm trying. I've had a cold for about the last week, so I'm... Oh, shoot.
Sorry, we tried and we asked the maintenance people to turn it down or turn it off so that this didn't happen, because this happened last month, and as we can see, it didn't work very well. So, I know, but it's computerized. We don't have any control over that. So even if we turn that down, it doesn't do anything. Yeah.
Yeah. So
Yeah.
like she said, so out there where the TV's at, that has volume, and so that's what the microphones are for. So if you can't hear in here, you can probably hear out there. So you can either see what we're doing or hear what we're doing, I guess.
That ought to get fixed.
So next, the court considered aesthetics. Like I said, it reaffirmed that aesthetics can be considered even though they're not part of the golden factors. There's really not a whole lot other than just be aware of that as you move forward. The court will allow you to consider certain things that aren't in the golden factors if you identify those as necessary to be considered by the county as you move forward. So in this case, it was what am I thinking of? Rural aesthetics of the county. So if you identify things that are particular to Shawnee County that you want to identify as important for amending the zoning regulations, those things could be considered. I won't read these, but this is the finding. These are the findings of fact that the court cited to in its opinion. It's mostly just I want you to get, these are the details that the county identified for the court that they wanted to highlight, and the level of detail that they went to and the things they considered. I think as you move forward, I try to get within the realm of what they did, because obviously a court has kind of put its stamp of its blessing on these. I think obviously we're going to be a little bit different than Wabunsee County in some of the things that we consider, but some of them we won't. And I think, did you give them a printout or will you provide them?
I will provide you guys, I will send this to you via email so that you have a copy of his PowerPoint and all of the details with the case law in it that he identified. I will see whether or not they have the ability to do that through IT. We don't have a wind and solar website just yet, or area on our website where we're posting items. And so I will talk with IT if
Yeah.
you're fine with it being shared.
Sure.
Yeah.
This is nothing new for you guys, obviously, considering the comprehensive plan is appropriate when amending your zoning regulations. The issue in this case came up because they instituted the moratorium and then adopted a completely new comprehensive plan and then adopted the zoning regulations. So obviously, landowners were a little irritated by that process. So that was essentially how that issue came up. Yeah, like I said before, they essentially reaffirmed longstanding case law that essentially zoning decisions shouldn't be made by a neighborhood vote, either for or against. So essentially, they're a valid consideration, but any decision should be made solely on that basis. I did want to highlight, there is an open question as to whether or not a countywide ban on wind farms, obviously wind farms were the issue in this case, extended to solar farms as well, is unreasonable per se or improper. The court sort of hinted at but didn't address fully. There's some pre-1970 law in the United States that basically says you can't exclude one use from a jurisdiction. I think in 72 or 74, the U.S. Supreme Court heard a case where a municipality had essentially zoned the entire municipality as single residential family living, so single family residential, and excluded everything else, and the Supreme Court upheld that. So since then, courts have gotten a little more lax on that, but that still exists out there. So anytime you're excluding a particular use from a jurisdiction, a court's going to give that a little bit more scrutiny than it otherwise would have. And then, like I said, I wanted to highlight, they held 54 meetings, I think, over the course of 2.5 years, and the county produced up to almost 400 pages of transcript and findings for the district court, and those were ultimately forwarded to the Supreme Court for their consideration as well.
Okay, can I ask a
Yeah.
question there? 54 meetings after the lawsuit was
No.
to
They
get
held
to the point of their regulations.
Yep. So now keep in mind, they did pass a comprehensive plan. So I assume the court is lumping together comprehensive plan and zoning regulate. Does that make sense? They
Yeah.
just said there were 54 meetings where the topic was considered at least in part. So I assume there were meetings where they considered both the comprehensive plan and amendments.
You ready for 54 meetings?
I just meant to provide context. So it's I'm not saying you have to have 54 meetings. So next, the court considered whether or not the adoption of the zoning amendments violated the contract clause. So this is the first part. That's the test the court listed in Zimmerman. The next one, I thought the Washington one was a little simpler to understand, so I provided that as well. They're saying essentially the same thing. So what a court's going to ask is, do you have a valid contract? Does the zoning amendment substantially impair that contract in some way? And is the impairment reasonably and necessary to serve a legitimate public purpose? Think of it this way. If you have a contract and it's substantially impaired, the third part of that test is basically going to be a lot like what we've been talking about up to this point. You have a public purpose, and that is your land use regulation. And the question is whether or not that's reasonably related to the land use regulation. Or have you gone completely haywire and you're nowhere near the mark?
Ken, do you
Sorry.
have a question?
Yeah, Ken.
So if someone entered a contract, a landowner, for the possibility of wind or solar, normally the contract would be probably, if approved through regulation. I can't believe they
Sure.
would sign a contract that would not give an out for somebody.
Yep. Yeah, so that's getting to the substantially impaired part. So in this case, there wasn't really any dispute that there was an actual contract between the landowners and the wind companies. The issue was substantial impairment and whether or not the zoning regulations substantially impaired that contract. And so kind of like what you're saying, Kim, the court's going to look at, in this case, it looked at, for substantial impairment, it was important that the industry was heavily regulated, and it identified both land use as heavy regulation and energy power is what it said. Energy power is heavily regulated. In that case, it identified the Kansas Corporation Commission. So you have essentially two aspects of regulation being applied to wind and solar. And the court said, basically, if you're in a heavily regulated industry, you're going to have a hard time establishing substantial impairment because you essentially enter into contracts knowing that the regulations could change at any minute. And then it did analyze, it said even if we assume substantial impairment, the zoning amendments served a significant public purpose. So in this case, the court found the public purposes it identified were aesthetics, consistency with the comprehensive plan, and environmental, ecological, and surface and subsurface water concerns. And I'll provide this all to you. I think it's in the broader outline that Joni's going to give you. But I found it interesting that the court went beyond what the district court had considered into kind of ecological and subsurface and water concerns. That the board I had identified it, but the district court just had simply ignored it. So this is, again, preemption. I'm going to skip right over it unless you guys have a burning desire to talk about it. Zimmerman 2, so like I mentioned before, this is the same case. Essentially what the court did in the first opinion was say, well, you've raised these other issues, and we want to give the parties time to address those. So they put the case on pause and allowed the parties to submit supplemental briefing, and then came back and rendered an opinion as to those other issues. So the underlying facts didn't change. It was just they wanted to give the parties time to address additional issues. Pertinent holdings. So the first was the amendments were not a taking under the Fifth Amendment of the U.S. Constitution and didn't require just compensation. The court didn't address the Kansas Constitution. There is some authority out there that the Kansas Constitution is more narrow than the Fifth Amendment, but either way, generally speaking, the Kansas court interprets our Constitution similarly to the way U.S. courts interpret the federal Constitution. The second holding that I found that might be relevant for the commission is the zoning amendments were not facially discriminatory against interstate commerce. And we'll get more into the interstate commerce issues as we go along. The court ultimately remanded the case to the district court for additional findings on the interstate commerce clause issue. Essentially said, we don't have enough facts to make an ultimate determination, so they kicked it back to the district court to make factual findings, issue a new ruling, and then the parties could go from there. And I didn't see any other action, so I assume they either settled or it was resolved in another way. Either way, it didn't come back up to an appellate court. So the Supreme Court held that the county's decision to amend the zoning regulations didn't constitute a compensable taking under the Fifth Amendment of the United States Constitution. So I wanted to explain, I don't know if y'all are familiar with inverse condemnation. So that's where essentially governments have the power of eminent domain. However, in that case, you have to institute formal proceedings, then you can take the property and pay just compensation. If a property owner feels like the government has actually taken the property in fact, but hasn't instituted formal proceedings, they proceed under an inverse condemnation claim. It's essentially the same elements, they just have to prove that a taking happened. So generally, there's three types of what we call regulatory takings or inverse condemnation actions. Denial of economically viable use, physical occupation or physical taking, and then benefit extraction or exactions. These slides are going to get wordy, so I apologize. I tried to narrow it down, but I couldn't. So physical takings or total takings, essentially what you're looking at there is your traditional taking. So a government has seized a piece of property. It also applies where there's been a permanent physical invasion of property. So the case that you most may be familiar with is Loretto. Essentially in that case, the city of New York instituted a ban on satellite dishes and then required apartment complexes to allow cable companies to run cable through their apartments. And somebody said, well, this is a taking and we require just compensation for it. The defense was, well, this is so minor, you're not going to notice it, it's not a taking. And the Supreme Court essentially said, it's a physical invasion of property, it doesn't matter how tiny it is, it still requires just compensation. There was a recent case in 2021, I think the Supreme Court handed down a decision regarding a California regulation that allowed labor unionizers to go and talk to agricultural workers, and they were allowed on the property. They were allowed on the property for a brief period of time. I think they had in between like 4 and 6 every day, and they could only utilize like 120 days a year. And the court found that's still a physical taking, even though it's temporary in nature. So anytime you have what they call a physical appropriation of property, and I'll be honest, the ramifications of that case are still kind of being worked out, so we don't really have essentially the court took decades worth of case law and upended it, because courts before the dividing line was permanent versus temporary, and the Supreme Court said, well, no, it's physical appropriation of property, and anytime you have that. The critical piece of these two tests are, if the court finds a taking, it's not going to really analyze whether or not the owner has any economical use left in the property. If it finds a taking, really the only thing left to do is determine damages and what the government has to pay. Benefit extraction, I think the best way I've thought about this is in your guys's, when you're issuing conditional use permits, the conditions you attach to that permit, that's these type of cases. So when a government attaches conditions to the granting of approval for development, that's going to raise these type of issues. And essentially what the court's going to look at is whether or not the conditions you attach are connected in some way to a legitimate government purpose, and whether or not the conditions are roughly proportional to the impacts of the development. So if you had someone putting in a storage facility for a hazardous waste material, you would identify, okay, what are our interests and what conditions do we want to put on, and are those attached to the interests? So the interest being we want to reduce the possibility of hazardous waste being released into the environment. And then what mitigation, and then the mitigation conditions that you attach to that have to be roughly proportional to the risk. Does that make sense? So you can't require, if they come in and say, well, we want to put X cubic feet of hazardous material on the ground, and you require them to do 3 times what is necessary under federal regulation, a court's going to say that's not proportional. Does that make sense? You obviously have a legitimate interest in mitigating risk, but it's got to be proportional. So this test, the Penn Central balancing test, that's going to be the most likely test that will apply to zoning regulations. Generally, when you're zoning, you're not physically taking property and you're not attaching conditions to development. You're zoning county-wide, if that makes sense. It's been narrowed over the years, as I put. So a regulation generally will not be held confiscatory or a taking unless, as applied, it denies an owner all reasonable, beneficial, and economically viable use of the property. Kind of the way to think about this is an owner has to be able to establish more than just you deny me the highest and best use of my property, or that essentially they're going to look at, do they have an economically viable use left in the property, and determine whether or not it was a taking based on that. And I put in here, again, read it with the caveat that there's recent case law that may change how we divide this, but temporary physical takings are subject to the Penn Central balancing test. Because of the recent case, there's no clear line on when a regulation constitutes a permanent physical taking. So Zimmerman 2, they alleged that their property rights were taken by the development, by the amendment of the zoning regulations. In this case, the court really didn't get to the second step because it basically said under Kansas law you had no property right to begin with that the government could take. So under Kansas law, you have to have a vested right to the property that was allegedly taken by the government. And a vested right is a right so fixed that it is not dependent on any future act, contingency, or decision to make it more secure. What they meant by that is, in Wabunsee County prior to the amendment, in order to build a wind turbine or a solar facility, you had to get a conditional use permit. So the court basically said, because your use of the property right was contingent upon the Board of County Commissioners granting you that right, it wasn't a vested property right that they could take in the first place. Does that make sense?
Yeah.
So they didn't decide the ultimate issue of whether or not it violated the Commerce Clause. So this is the last issue that they analyzed that I'm going to talk about. Again, they remanded it. So essentially under U.S. Supreme Court's, this is a very simplified version of the test. Under U.S. Supreme Court case law, a state may not directly regulate, prohibit, or burden interstate or foreign commerce, cross out the foreign part, but may incidentally and indirectly affect such commerce by a bona fide, legitimate, and reasonable exercise of its police power. So sort of going back to physics or civics class, one of the reasons the Constitution was passed was because under the Articles of Confederation, states could regulate interstate commerce and essentially ban out-of-state commercial activity from entering the state. So when they passed the Constitution, they granted that power to the federal government. And courts have found implicit in that grant of power was a restriction on the states or local governments from restricting commerce from flowing in between the states. So they want to, we retain bona fide police powers, and so the court's obviously balancing, okay, yes, this restricts interstate commerce, but localities still have police powers that they can exercise. So the court will first analyze whether or not it discriminates on its face. So essentially, imagine if Kansas passed a law saying you can't sell pork that was not manufactured, but pork that came from out of state. You have to, if you're selling pork in Kansas, you have to sell pork that was created here. Those type of things obviously are facially discriminatory against out-of-state commerce. As long as it doesn't discriminate on its face, the court will move to the second step, which is it balances under Pike. So as long as the burdens imposed on such commerce is not clearly excessive in relation to the putative local benefits. The number of cases, and honestly, I highlighted down here the court is rapidly churning out interstate commerce cases. If you're interested, National Pork Producers Council versus Ross is the most recent one. And honestly, why it's important is at least 3 of the justices signed on to a concurrence that would have basically done away with the pike balancing. They don't have a majority, obviously, but there's at least a portion of the court that wants to do away with it and solely focus on whether or not it's discriminatory. That's sort of an interesting, we'll see where the court goes with that. But that case was the case that came out of California where they amended their constitution requiring all pork sold in the state to have been raised within facilities meeting certain requirements. So the national pork producers brought suit alleging a violation of interstate commerce, and the court found that it wasn't a violation of interstate commerce. It obviously didn't discriminate between in-state and out-of-state producers because in-state producers also had to comply with the requirements, and there wasn't anything. The court found that it wasn't an excessive burden on interstate commerce. I think why I found it interesting in relation to what we're doing is, again, there were 3 justices that if they didn't get to do away with pike altogether, they wanted to limit it to where it wouldn't apply where you're balancing economic issues or economic burdens versus non-economic local interests. So in that case, you obviously had economic interests of the pork producers versus non-economic sort of environmental, and so that sort of applies similarly here, where you're going to have wind and solar producers on the one side saying these are the economic impacts, and you have counties on the other side saying these are the aesthetics concerns, and the court's basically saying how's a court supposed to balance those two? Like what's, there's no objective test in that situation. I'm not gonna, sorry. I basically went through these. I kind of talked more on that slide than I thought I would. So again, they remanded it. The court mentioned that it could not know how much electricity would be generated from the county wind and eventually kept out of the interstate power grid if there were no board prohibition against commercial wind farms. So in essence, they said we don't have enough information to do the balancing test, so we're sending it back to the district court. Again, this was obviously pre some of the recent developments at the Supreme Court, so it's sort of unknown if we were to get in that situation, or a county in Kansas now were to get in that situation, how that would play out. These I partially stole again from Trish and added some of my own in thinking about some of the questions you guys have asked during meetings that I've been to or reviewed, some of the questions that were raised that I had as I was going through everything. So does the comprehensive plan address these uses? Does the county zoning code already allow these uses by right or a conditional use permit? And then obviously consider analogous examples. So utilities, other services, transmission lines, energy storage. Again, fairness considerations based on analogous uses, unzoned land uses, if we have any. And then, do we sufficiently understand physical components and operations? Durations of permits and approvals. That obviously may not apply here. I think I stole that one from her, but she brought up repowering, and that would be one thing to consider in terms of when they need to do technological updates to them, and how that looks and what they bring in and how that all operates. And then how to address industry technology and safety changes. Obviously this is a continuing process, so as the industry develops, as it becomes presumably more safe, how will we either mandate that they comply with the updates, or how will we address that? Because as we've heard, some of these leases can go a fairly substantial period of time. Again, should we talk to Public Works about their concerns? And one thing I thought of, both Trish and Mr. Savati brought up energy storage facilities. That was one thing that I hadn't considered before, and I didn't know if they even consider doing energy storage facilities separate from a solar facility, and how that would work. You know, given that we have solar facilities being built in counties sort of contiguous to us, maybe that's something to think about. And then an individual from the Kansas Corporation Commission forwarded Joni an email, and he laid out some of his, in that email he laid out some of his concerns, or at least, not concerns, he laid out some of the things that he identified for Douglas County to think about as they were going through their updates to their zoning amendments. So I just included those. I thought they might be helpful. I believe by ROW he means right of way.
Mhm.
Just let me know when you're. You good?
Mhm.
Okay. Yeah. So, again, some of this I borrowed from the presentation, and some of it I added. But topics common to wind or solar utility land use regulation. So you have aesthetics, view, noise, lights. Mostly considering non-participating neighbors, others in the community, others not in the community. I think what Trish was getting at is you don't want to necessarily exclude, purposefully exclude people from the community, if that makes sense. So for wind or
what?
purposefully exclude, you don't want a spot zone, essentially. Is that kind of what you got?
There's not in the community. So I wonder if she's meaning aesthetics, view, noise, light, non-participating. So participating neighbors would obviously be people who have their farms or their properties under lease, and so others around them would be non-participating neighbors. Others in the community, I wonder if others not in the community just means the general public, people driving through,
Gotcha.
people outside of the county. So we can't just identify, or you don't want to necessarily discount people who don't live in Shawnee County
And their opinions of.
and their opinions of it, right?
Okay. So rural view, rural characteristics, including typical recreation, hunting, fishing, that sort of thing. Setbacks, screening, view shed, so that would be blocking, mandating trees surrounding the project. Agricultural land preservation. She identified this, I suppose, as a as a project that's supporting long-term preservation and increased productivity of soil due to rest, water conservation, just something to think about. Wildlife or other environmental considerations, hazardous materials, health effects. And again, scale of development, utility versus community or local resource. Obviously, do you want it to be a large farm sold to the power pool, or do you want it to limit it to local consumption? I think if you limited it to local consumption, we'd obviously have to work out the details, but you would presumably want to limit it to where someone is building a solar project just for their use. And that would, I think, based on the Kansas Supreme Court, eliminate some of the interstate commerce concerns, but I don't think you could say, yes, you can build a facility here as long as you only sell to local customers. Does that make sense? So you want to consider property values, on-site storage, laydown areas, decommissioning, restoration, and disposal. Again, road system conditions, assistance with costs of road upkeep, local careers, jobs, property taxes, community harmony, community role in supplying renewable energy. So in our presentation, these were common within county, these were common agreements that counties that weren't zoned had entered into with wind and solar facilities. She highlighted them mostly to highlight what they had considered and sort of restrictions that they had placed on. So she highlighted for zone counties, it was mostly about, do we also want to incorporate some of these concepts into our zoning regulations, if that makes sense. I should mention, I think she represents mostly landowners, so she's seen the agreements mostly from the landowner perspective. So first was a development agreement. So you have your initial county approvals, further county approvals in cooperation not unreasonably withheld or delayed, regarding existing or new county regulations, permitting, and or approvals. The grandfathering, I don't think that would apply to zoning as long as, but no commitment to construct or operate project. Obviously, project siting and development terms or regulations. So you have your turbine setback from roads, dwelling, non-participating property lines, cities, turbine lighting. And we'll get to Kansas, I think, recently passed a turbine mitigation act. That'll be in your materials. Sound, ice throw, flicker paint. I did think type of solar generation technology. For me, that was mostly, do we want to consider or the possibility that we could mandate that they use the most up-to-date technology, the most up-to-date safety comply with the most up-to-date safety regulations, that sort of thing. So your road use agreement, pre-construction planning and road route and improvement approvals. So mostly this is allocating costs and performance rules of road maintenance and repair during construction phases and during life of the project. And then identifying a single point of contact for the developers to contact regarding the road use. Presumably that would be your county engineer in their department. Mouse is touchy, sorry. And then a decommissioning agreement and what happens when they ultimately have to be decommissioned. I added so Kuntz exaction on the pilot. Those are my words. Kuntz was the case out of the Supreme Court in 2013 that found if a county or a local zoning authority demanded payment of money, that could still qualify under the Fifth Amendment. So in that case, Florida essentially demanded of a property owner, if you want to develop these extra 2 acres of your land, you can either pay us some money to offset the environmental harm over here and we'll do the work for you, or you can do the work. And he chose neither and chose to sue, and the Supreme Court said even a confiscation of money could qualify under the Fifth Amendment. So that was just, I'm not saying it's a huge issue, I'm just saying if demanding payment in lieu of taxes is something we're wanting to consider, we'll just want to consider the takings implications and how to work around those. I don't think it would be an absolute bar. We would just want to talk about different options that we might have. Okay. I do have, from my outline, there's other relevant material. It's basically just citations of statutes. So it has contained in there is like the statute that exempted them from property taxes, the statute on the Kansas Corporation Commission jurisdiction. I think Mr. Savati covered that pretty well. I didn't see anything in there that I would disagree with him on in terms of they obviously don't have jurisdiction over the siting. If and when the project becomes a public utility, then they would step in. I included the Wind Turbine Light Mitigation Act. That was passed by the Kansas legislature, I believe, this last session. I also included, there's been an amendment to the Federal Power Act that may be relevant. They're sort of working through regulations, and I expect they'll roll those out within the near future. Essentially, I'm blanking on the name, but a recent federal act gave them updated authority to regulate transmission lines and the siting of transmission lines. So they're sort of working through regulations on that.
Okay. Thank you, Kyle. Any questions from the group here for Kyle? Looks like you're done now.
Okay.
No, I'm just moving this,
I'll
so
just
when
kidding.
we're ready.
You almost got away.
Nope. If you guys have questions, now is the time to ask them.
I did mean to say this in the beginning. This is just, I'm hoping to provide you information so you can identify issues. I'm not saying anything in here prohibits us from acting in these areas. I just wanted to make sure you guys are aware, hey, these issues are out there and there are potential solutions. We just need to be communicating, you guys with Joni with our office. As you have ideas or proposals, let's talk about them, let's figure it out.
Okay. Thank you. Yeah, question.
Just one more question, sorry.
Yeah, no, go for it.
In the Wabunsie case, the Zimmerman case that you were talking about, can you clarify again, they put a moratorium in, and then they did the comprehensive plan, and then finally followed up with regulations?
Yeah, so they had a, oh, go ahead.
And then my real question is and at that point, the wind companies sued them?
Yes. So they had a comprehensive plan, and I believe what happened was a wind company contacted the planning office, the county planning office, exploring sort of how to do this in Wabunsie County. The planning commission, or the planning director, went to the Board of County Commissioners and said, hey, by the way, this guy reached out to me. And they, at that point, instituted the moratorium. They had a comprehensive plan before the moratorium, but they realized that didn't really address this issue. So they instituted the moratorium, did the updated comprehensive plan, and then did the amendments to the zoning regs.
Which is one of the reasons we've been talking about, we need to do something before we're approached.
Yeah, I mean, it's not a bad
Possibly.
idea. I do think, I didn't do a lot of research into moratorium law, just because I just didn't. So if that's something you want to explore, I wouldn't mind a month to look into it just to make sure we're not stepping on any landmines, but I don't see anything. But it's definitely something people have used in the past. Like I said, it raised taking concerns for Saline County. And there they ran into, the gentleman owned agricultural land. The city shut down his grocery store, I think, through some sort of action, and he was gonna build the store on the ag land, but before he could institute that proceeding, get the permits, the city instituted the moratorium. So the court found, well, you were thinking about seeking the permit before the moratorium, so there wasn't a vested property interest. My only point there is, depending on where the landowner is at in the development process, you may have takings issues, but does that make sense?
Yeah.
There's also, I think, several cases on non-delegation of the authority, so in that case, the board would want to be the ones instituting it and passing any extensions of the moratorium. It's not something that they would want to delegate to you guys. I think that would be, excuse me, an unconstitutional delegation of their power.
Okay. Any other questions? Okay. Thank you
Okay.
for that report. And our next item is next steps with wind and solar farm regulations.
So I don't have a specific presentation on next steps. I know at last month's meeting, we discussed it a little bit. And so I wanted to bring this back to you for discussion so that you could make some choices. And we wanted to have Kyle do his presentation about the legal issues surrounding how we go through these steps and what should be considered as you take those steps, so that we make sure that we're not skipping ahead and doing things prior to the actual consideration of the facts. And so I don't have anything specific to talk to you about with the next steps, and if you guys want to discuss items at this point about what the next steps should be, I think that Kyle and I both feel as though the presentations that have been made to you have been done so to prepare you, to get you up to speed with where things are at, to have you know and acknowledge what it is exactly that we're doing. And then at this step, we need to kind of decide which direction are we going and what do you want to do next. My opinion is prior to any town hall meetings, we need to have some level of proposal or a decision about what that proposal may be, so that I, as the planning director, then have the ability to put staff reports together and have that proposal for you to be considering and for the public to be looking at and to be commenting on. As you're well aware, this step and the consideration of these regulations has to happen just like we do a conditional use permit or any zoning amendment. We have to go through the application process. Okay, well, we're here. We're applying for, are we going to do, solar and wind regulations? So then the next step is, what exactly are we asking for? What is the proposal that we want? What do we want for wind? What do we want for solar? And then I, as the staff, along with people within my office, we do the research. We have proposals put together. We reach out to the various departments. We go through all of the golden factors and we see how those things fit within the golden factors fit within the proposal that we're wanting to consider. And then we come to you with those proposals to look at, to vet, and then we get to the point where we're doing the public hearings, just like we do with a conditional use permit or with a rezoning case, where you hear the presentations on the pros, you hear the presentations on the cons, you have the ability to ask questions, to make changes, and we go through it. And so my take is that while the community input is one part of this, as Kyle was discussing, that's one aspect of what you have to consider when you're looking at whether or not we are going to do wind and solar. You need to have the background of why it is that you want to either have wind and solar regulations, or in the alternative, the background of why you want to ban wind. And you need to, or wind and solar, you need to consider all of the factors, the aesthetics, the zoning regulations, how this affects our roads, the taxes, all of the things that Kyle had listed up are things that you should look at as a part of the golden factors of what you consider, and so that in the future, if it ever comes into question, then the courts can look and say, yes, the Planning Commission looked at all these factors, the decision that they made was reasonable, and then they made that recommendation to the Board of County Commissioners, and then they too took into consideration those facts and considerations and the recommendations of staff and made a reasonable decision. And so I would open it up to the Planning Commissioners for some input on how you think we should start moving forward.
Ken had a question or
So,
comment.
Well, anyway, I'm here to, this won't happen tonight, but I'm here to make a motion that we ban industrial and commercial wind in Shawnee County, put a 3-year moratorium on solar to give this commission time to do its job, so we don't get this county in effects we can't get out. So that's my thought, and it's open for comment.
You got a thought?
I feel like with the meetings that we've had, pretty much everybody at all the meetings we've had, the 2 people at the first meeting, the wind guy at the second meeting, even the wind guy said that Shawnee County wasn't a good place for wind. The commissioners have all pretty much publicly said that they aren't for wind, so I think that we should separate the wind and the solar, ban wind, and look at solar separate.
Would we still have to have some regulations for individuals that might want a turbine for their own individual use? Or a company where they maybe are, it's on their property and they want to have a turbine or two? Would we still need to have regulations for them?
Well, so the way that we operate right now is that if you are utilizing a solar farm, in Shawnee County, we have not had a request yet that I'm aware of, for a wind turbine on personal property that supports one's own energy usage. We do all the time get requests for solar, not necessarily solar farms, but solar panels.
Sure.
And we don't have regulations that regulate how people use those for their own production that's not being sold or not being used by general consumption. In essence, we do it through our building permit process, where they come in and they have to comply with standards for towers or standards for buildings, where you apply for a building permit for use on your own land. Now, I think that we would have to consider on wind, if a personal wind turbine is small in nature, how that might be in comparison to a utility scale or a large wind turbine. We haven't looked at that in particular, and so I think that we would need to do some exploring on whether or not we would allow wind turbines if you instituted a ban to do that. Now, I will say, in your discussion here tonight, we cannot just vote and ban wind tonight. What that would mean, as Ken was saying, I'm not going to do this tonight, but what this would mean was, if you want to take a move towards banning wind, then our proposal that I would be looking at would be the ban of wind, and all of the reports, all of the, everything that I put together would be towards you moving towards considering having a public hearing on the ban for wind. So no ban tonight, just the consideration.
And as I stated in my motion, it was just industrial and commercial, had nothing to do with homeowners, anything.
Yeah, thank you, Ken.
I mean, there definitely are homeowner owned small wind turbines mounted to buildings here and there in the county. It's not like it hasn't happened. Maybe they aren't applying for it. I don't know the
it may
there.
depend. Like, I know there's one in the city of Topeka city limits, and since I've been the planning director, we haven't had anybody apply for a building permit for a turbine. I will say that we get permits for people to do like ham radio towers or cell tower, communication tower type things that are personal in nature. So it would probably be treated similar to that. We do have height restrictions, and we have regulations that limit how those go up. And so I would assume we would do it similar to that. That's not a public utility. So if it's being sold outside, then it falls under the public utility zoning, and then we have to process it as a conditional use permit, so it's a little bit different.
Okay. Other thoughts? Brian?
Speaking to you guys, but talking to the mic here. It seems to me that everything that we've heard so far has been mostly negative characteristics for the county and the public as a whole when it comes to commercial scale wind. And so I'm in support of what we're talking about tonight in moving toward a ban on commercial wind. So that's what I would see the direction if, you know, if we talked about that tonight. And for me, solar would be limited to a certain size.
Thank you,
And,
Brian.
I would say, in addition to that, that one of the considerations you can absolutely take in what Josh mentioned was separating the two, where you make a decision on wind and then move forward on solar in some manner. Ken's motion was a moratorium for 3 years. That language would definitely need to be sorted out a little bit. I don't know that you can say 3 years. I don't know that there may need to be a sunset. There may need to be a timeline with a refresh period that can be reconsidered, because it's not going to take us 3 years to get through the solar regulations. We're not going to take that much time.
Yeah.
So 3 years is pretty extensive.
Okay.
But to that effect, you know, I think that we would want to make sure with case law that whatever the limitations are that we set with that moratorium, and just remember, anything you do here is a recommendation, and still the moratorium, the ban, all of those things, you consider them and you hear them at public hearings here, and you make a recommendation to the Board of County Commissioners, and then they go to the BCC where they also hear them and consider them and then make the decision at that level.
Okay, thank you. Chad or Jeanette, thoughts? Or would you be in favor of thinking about this over the month or until next meeting, or do you have something in mind?
Well, without having to have 54 meetings, I think I wouldn't mind moving forward and letting Joni's office go and put a proposal for separating wind and solar.
Okay. I think that's a good idea also. You agree, Jeanette?
Yes.
Okay.
Can you repeat that? Yeah, we couldn't hear that.
Chad,
Chad,
couldn't hear what you
speak
said.
up.
You were not talking.
Do you want the joke first, or you want No, I think I would probably recommend moving forward and letting Joni's office put a proposal to the planning commission for separating wind and solar, so.
I think that makes sense to handle one issue and then the other. I agree with Brian and Ken in that I don't think Shawnee County is a great candidate for wind. I am in favor of renewable energy, but the amount of landowners that we have in Shawnee County, the size of the property that people own is small. I mean, Forbes Field is here, and I don't think Shawnee County lends itself well to large-scale commercial wind. So I agree. I think we can move faster though on solar. I think solar might be a good option depending on the size, but I think we could move forward with solar, you know, in the next year or two. So that's my thought. Ken?
Would it be easier for the commission to maybe swallow maybe the ban on wind as proposed, but maybe just a moratorium on solar for 1 year to let the group kind of get its feet under it? Would that be a motion for the next meeting, if you could agree on that?
If we did a moratorium for a year versus not doing a moratorium, what's the difference? Like, how are we affected by that?
Are you asking
Me?
Yeah, I couldn't hear. Can you speak up?
So, Ken wants to do a moratorium. Everybody else seems kind of like they don't want to do that part of it because we feel like we can go So what's the difference between doing a moratorium and not doing a moratorium?
Well, as you guys know, we had this discussion previously. We had a discussion, we had meetings on a moratorium, and the Planning Commission wanted to do a 6-month moratorium. The difference being, we can continue to go forward with creating the regulations without a moratorium. The question becomes, with case law, if we get a proposal and there's no moratorium in place, do you have the authority then to say, well, whoa, we want to stop this proposal right now until the regulations are in place, so we want to put a moratorium in now, and does that cause issues with the fact that someone has submitted a proposal? So that would be the one consideration. As I've well mentioned time and time again, we have no proposals in front of us. We are not aware of any. And so, you know, I can't say that there's not going to have one show up on my door tomorrow, in 6 months, in a year. And so, you know, the question is, do we take the potential for receiving that application and do it like we did the first 2 solar farms, which is as a conditional use permit? Do you put the moratorium in place for a year, 6 months, however long, and see if we can't get the regulations in place first? And really, that's a decision you have to make on why. And if you want to say, we feel like this moratorium is very important because we don't want to put the county at risk for a lawsuit if a case were to come in during this time frame.
Ken?
A playback on that would be, she is right. We've had 2 solar projects that we weren't ready for. And they were almost, I'm not going to say clustered, but I think the solar people need to see what we have for our restrictions and our guidelines before they apply. And I don't want to work these solar projects whenever they pop up, not knowing what's going to happen. If you want solar to really go in this county, take a step back, get your shit together, so everybody knows where you're at. And I just don't want to play it piecemeal, but that's just my thought.
Okay. Brian?
How much notice did we have with the Free State solar locations?
So typically, it's no different than any other conditional use permit. The way that we have our schedule set, so I took over as interim director at the very end of April, and you guys heard those in May of 22. So they would have had to have applied in March, I think in March, for us to hear them in May, the first or the second Monday of the month in May. So the way our schedule is set, so for instance, we have a deadline December 22. If someone comes in with a proposal by December 22, that gets heard by the Planning Commission on our February meeting. Now, when people come in with proposals, I, as the planning director, can say, hey, this is something that's going to need a little extra time. We really need you to not be heard until March, April. But if they push, I would have to bring it to you. If they say, nope, I want my application heard, this is what's considered, I would at least have to come to you with the proposal, and you would have to consider whether you would ask to defer action to another time.
And have you had any proposals come in for
No.
solar, for
No,
additional
oh no,
solar? Okay.
no. Now, I will say that we have several other, don't forget, you still have other planning items, and we do have several that will likely get filed either prior to the December deadline, or I'd be surprised if they don't get them filed by the December, but I anticipate that we will have a meeting in February where you're going to be hearing some conditional use permit applications. And
Okay.
so while we're doing all of the wind and solar stuff, we still have to go about business as usual with all of our other proposals if they come in to the office.
Okay. Yeah, Brian?
For a moratorium, does it have to be a certain length, or could it be until regulations are complete.
Kyle, do you want to, I'm sorry to put you on the spot. From my recollection, when we researched this before, I feel like every county that we are aware of has put a time limit on it, but said that if the regulations are approved prior to that time limit, then the moratorium would be lifted.
Okay.
I know that Pot County
What- yeah.
has considered that or done that, Sedgwick County, Osage County, but I feel like they each put a deadline which it would expire and then would have to be reconsidered to expand it. And they can, as Kyle said in his discussion today, they can be expanded. And Pot County did that, they expanded theirs. I feel like there was one other that had expanded theirs as well.
Yeah, I think Wabunsee expanded.
Yeah.
I think theirs was, well, I mean, theirs was 4 months, right? And so they extended it in 4-month increments for 2.5 years.
Oh, okay.
So,
Okay.
I think the longest I saw was 6 months, but. Yeah, it's.
Okay.
I mean, it's
Okay.
just, I only mentioned that so you guys were aware. I think if you saw it coming down the tracks that, hey, we're gonna need more time, you would make a proposal to the board, hey, extend the moratorium, the board would extend the moratorium. You would just need to think ahead,
Yeah.
month, 2 months to get that done.
Okay. Yeah, Brian.
So I would be in favor of a moratorium on wind for a period of time. A year sounds
On wind?
reasonable. I'm sorry.
Solar. Oh, yeah,
Solar.
thank you.
Ban wind. Moratorium on solar till we get because I don't, it's interesting being here. You think you can make all these decisions and then somebody's sitting at that podium with a proposal and you're kind of, what decision can I make besides yay or nay? So I don't want to be put in that situation. I don't think the county should be put in that situation. So I would be in favor of a moratorium on solar.
Okay. But since we're not going to handle that tonight, that's something we can all keep in mind for next meeting. If we want to do a moratorium, and if so, how long we should do it. Yeah, Ken.
So will there be anything on the agenda, what we've talked about, next meeting?
So
Will there be a motion on there?
what I would like to see is, Ken, if you could amend your motion instead of just saying I want to ban and do a moratorium, that you propose that we consider banning and a moratorium so that I can then create the effort to put together. Now the question being whether we can get all of that accomplished by January, because you have to recall we have a holiday and a bunch of stuff that will happen between now and our January meeting. And so I'm a little concerned that we're not going to have time to do so in January and that we may need to do it for our February meeting. And that would allow me to work with the county counselor's office to ensure that we have the proposal. So I think you make your motion tonight and you say, I propose this is how we move forward.
Okay.
And then you have a second and you can vote that this is
Okay.
how we're moving forward so that you're directing me on how to move. But I don't want to just say for certain that we can have this accomplished by January. If you want to have a work session in January, maybe we consider that. We can kind of get an update to where we're at. But this is a pretty significant move that you're making tonight, and I want to make sure that we have all of our ducks in a row and the report's correct and can reach out to everybody that we need to in time.
Okay. Ken, can you do two, if you intend to make your motion, can you do one for wind and then a second one regarding
Yes,
solar?
I can. So the first one would be, on the next meeting, whenever it's held, consider a ban on wind, commercial and industrial. And the second motion would be to have a moratorium on solar for 1 year.
Okay. All right. Do I hear a second on the first motion?
I'll second it.
Jeanette seconded.
Seconded by,
Who's second?
Jeanette.
Can I ask for a clarification? So this is to get your team going, to consider it, so we're, okay.
And this will be a recommendation to the Board of County Commissioners that we ban wind.
Yeah, which we'll vote on that next week.
Okay, so we've had a motion and a second. And we're only dealing with
One.
one right now.
The first motion regarding wind.
Tyler Timbrink,
Yes.
Josh Greening,
Yes.
Brian Aubert,
Yes.
Jeanette Johnson,
Yes.
David Linderman, Ken Corbett,
Yes.
Chad Depperschmidt,
Yes.
with 6 votes in favor. The item is approved to be considered at the next meeting.
Thank you. Do I hear a second on the second motion regarding solar, 1-year moratorium on solar?
Second.
Chad Depperschmidt,
Yes.
Ken Corbett,
Yes.
David Linderman, Jeanette Johnson,
Yes.
Brian Aubert,
Yes.
Josh Greening,
Yes.
Tyler Timbrink,
Yes.
with 6 items in favor, or 6 votes in favor. The item on the moratorium will be considered at the next meeting.
Okay, thank you. Moving on the agenda, we'll have public comment on non-agenda planning and zoning items.
Okay, so we know there's a lot of people here today, and we know that you've heard all of the things that have come up at today's meeting. We will allow public comment at this point from people who wish to speak. Tyler, 2 minutes?
2 minutes.
2-minute limit on anybody who wants to speak. And I do want to make sure, at last meeting, people wrote their names down, but you have to put your address and all the information as well. So make sure not only to say your name out loud so we get it for our minutes and for our recording, but then you can write down your address next to your name as well.
Okay, would anyone, we have a volunteer.
Can't write. Better system and everything, right?
And go ahead and have a seat. I know that it's different than having a podium, but because of the microphone recording, make sure and sit down so we can hear you.
Then we have the difference.
It's about to be
My name is Rick Barker. I live outside of Wakarusa in Shawnee County. I would like to request you research the technology for having microphones in this room, since we can't turn off that.
Second that.
I have seen it in numerous other meetings. You can do that. And, I mean, get a karaoke machine and pass a microphone around. Okay? What was the second one? Oh, I would like to have access to the PowerPoint because he went through so fast. Can we send an email to you?
Absolutely.
And then request that and
Yeah.
get that?
Yes.
Thank you, Rick.
And I will say that I've been working with IT on either a location change, microphones that amplify other technology, and I've been working with facilities to get the vents taken care of, but it's definitely a work in progress.
Anyone else?
name's Terry Kaufman. I have an abiding interest in the development of utility-scale solar in another location. I'm not invested in it, but I'm very much invested in the possibility. I won't say, you know, how I feel about it, but I did send an email regarding the survey that apparently was made known sometime in September on one or more TV stations. And my career is in the survey business. So I just want to say, I'm going to quote a Nobel Peace Prize winner, not for surveys, but for physics, who said about some topic, not only is it not right, it's not even wrong. So I suggest to you, I beg of you, not to take the results of that survey literally in any way, shape, or form. No matter, I did look it over and dug into the links that let you dig a little bit deeper, but that's sort of like digging a hole in the wrong place. So that's all I want to say.
And your email was in the packet that was provided
I know
tonight.
that's
Yep.
right. Thank you very much for that.
Thank you, Terry.
There's plenty of opportunity for community comment, but I hope that's not part of it.
Okay. Okay, we'll move down to discussion of planning-related issues.
So I would like to put Mr. Barr on the spot and introduce Chadwick Barr. He is going to be starting next week as our new zoning and floodplain manager. And so you will likely see him around.
Can you get a picture now before he gets a job?
So he will be starting next week. They just moved here from Mississippi. He went to Iowa for planning degree back in the day. He worked in Reno County, McPherson County. He's worked in Arizona, Iowa, other locations here in Kansas. Most recently, he was in Mississippi and applied for the position and had outstanding interviews, and we are very pleased that he will be starting with us next week.
Thank you for that. Welcome, Chadwick, and welcome to the Topeka area.
Thank you. My wife and I got into town last week, and we're very pleased to be here again. And most of my experience is in Kansas with counties, and so I'm very excited to be doing that again in my career.
Very good, very good. Welcome aboard. Okay, do I hear a motion to adjourn?
Motion to adjourn. Second.
Second. All in favor? Aye. Aye. We are adjourned.